Today's webinar is presented in partnership with the National Immigration Law Center. Shelby Gonzales, Director of Immigration Policy here at the Center on Budget and Policy Priorities, is joined by Gabrielle Lessard, Senior Policy Attorney at the National Immigration Law Center. They will cover information about concerns immigrants and their families may have as they make decisions about enrollment in marketplace coverage, Medicaid, and CHIP. With that, I'll turn it over to Shelby.
Thank you, Ina. And hello, everyone. I really want to thank Gabrielle. I know that Ina already did, but I just want to give another special thanks to Gabrielle and also to my colleague, Kyle, who's here with me in this room today that won't be presenting. Gabrielle, Kyle, and I worked really closely together to put these slides together in hopes that we can demystify some of the kind of evolving policy grounds that has been happening on the immigration front. I really want to start by just kind of naming it in some ways. I think it's important for us to just remember, and I think everybody probably knows that's on this webinar today, that there's been a real climate of fear, and many immigrants and their families have serious concerns about interacting with the government as a result of that climate of fear. There has been a steady stream of anti-immigrant rhetoric, increased immigration enforcement within the country, including in locations that have been considered safe in the past. Many efforts to stop people from claiming asylum on the southern border, and efforts to end the DACA program and the TPS program. And the administration has pursued many policies that would directly impact immigrants and their families' use of public benefit programs as well. This includes radically changing the public charge immigration policies, making it very difficult for people who are not already wealthy to enter the US or to adjust their status. Gabrielle will explain more about this and how it relates to health coverage programs. And just want to make sure to clarify that there has been efforts to radically change this policy that Gabrielle will talk about what the existing policy is, as well as what the government has tried, is attempting to change it to. So right now, we will be talking about both sets of policies. Also very recently, the administration also announced it would begin mandating health insurance coverage for new immigrants entering the U.S., certain people that are trying to immigrate, I should say, from outside of the U.S. And I'll explain more about this later in the presentation. The administration has also asked states to relook at the way they treat certain immigrants who have sponsors when they're making eligibility determinations for certain public benefit programs, including Medicaid. And this includes looking at how they factor in some of the sponsors' income into making eligibility determinations. We will not go into detail about this in this webinar. This is really not a new policy, but it is concerning that states may make changes that would result in people falling into gaps where they no longer qualify for Medicaid based off of some kind of new formula that's utilized in calculating income, and yet their income, when you use the marketplace eligibility rules, for counting income, would make them ineligible for marketplace coverage. So we're guessing that states are have not modified anything yet, but we do believe that states are at least looking at their processes and procedures based off of this request to relook at their processes. And we're super curious as to how states might be approaching this, and would be very interested in talking with you. So if you have noticed a change in your state related to how immigrants who are sponsored are treated, we would love to hear about that. So that's a plug for some information. Finally, there are other changes to policies related to eligibility of immigrants and other benefit programs like housing that the administration has also been pursuing. All of these actions have resulted in people being concerned and sometimes confused by the evolving policy environment. what's been clear to people is the message that there's a desire to constrain access to benefits among immigrants and their families. And that has left people fearful about accessing benefits, even if they have very little to be concerned about in reality. So in other words, even if these rules or these changes really have no impact on either their eligibility for health or economic support programs in one way or the other, even if there's nothing there, which, by the way, the policies that we're going to be talking about are immigration, policies, not public benefit policies. So there isn't a change in eligibility in the policies that we will be going into depth about. But also, but nonetheless, people are concerned that there might be some kind of ramification on either their own desire to change their eligibility status in the future. I mean, they're not their eligibility, their immigration status in the future, or the immigration status of somebody in their families. So we call that, and we sometimes refer to it as chill. People are chilled from accessing benefits for which they're eligible for as a result of kind of confusion and fear or of not knowing what the potential ramifications are. And just to kind of put a clearer lens on what this means for families and why families might be driven to forego benefits for which they're eligible for, is that oftentimes when they're thinking about their immigration goals for their families, somebody in their family, maybe just one member, maybe two members, who knows, what they're concerned about is their family's ability to stay together. That's what's at stake for them. So the stakes are very high and people's concern levels are very high. We're going to cover a lot of ground today, and I want to start off with some key takeaways. One is that accessing ACA premium tax credits or cost sharing reductions to enroll in marketplace plans would not label a person public charge under current policy or in rule changes the government has proposed. That's important for us to keep in mind as we head into open enrollment. Having insurance is a positive factor in the public charge test the government is seeking to implement. That's also important for people to understand. Most people who meet Medicaid eligibility requirements are unlikely to ever go through a public charge assessment. What I mean by that is that the eligibility requirements for somebody who is an immigrant, who has not become a naturalized citizen, it's pretty restrictive. There's a lot of immigrants that are left out of being able to qualify based off of their immigration status. So who we're left with are a lot of people who likely are not ever going to go through a public charge assessment. So that's important to keep in mind. The last point that I want to make is, I think I made it a little bit earlier, so I won't go into much more detail, but far more people will forgo benefits out of fear and confusion than those whose use of benefits would ever result in a negative immigration consequence. So I also want to talk a little bit about what the role is of consumer assistance providers. And I'm starting with this because I've heard a lot of people who really, have come to me and they want to say, tell me when I am safe to tell somebody that they're safe in terms of enrolling in public benefit programs. And I've also heard a lot of people who really want to become immigration policy experts themselves, or they feel like they have the pressure of being an immigration policy expert. We don't believe that this presentation is going to make you an immigration policy expert. This is probably not something that can happen for you between now and Friday when open enrollment opens. It's a tall order, and we're so excited that we have an immigration policy expert with us on the webinar today. But that is not a role that we think that you have to play. And most of the policies that we're going to go cover today are immigration policies, not health coverage policies. Your role is not to become an expert or to tell a person what they should or should not do. And I know that there's a strong desire to tell people that you'll be safe and that it's fine to enroll or to not enroll, right? But really, that is not what we are, best able to do as people who are experts in health enrollment. What you can do is to provide the facts. You can walk consumers through resources like the one that we have a picture of here. There's many other resources that are also that have been developed that detail current policies and can help consumers, can actually empower consumers to make informed decisions for themselves and for their families. We can also provide information about the value of comprehensive health insurance. That's definitely within our lane. We know what, the kind of financial security that comes with having health insurance. We know that that there are very positive effects in a person's life for having health coverage. And there's a lot of risk of not having health insurance. And we can also provide information about privacy protections related to information shared for enrollment purposes. And I will go through some of those privacy protections at the end of this webinar. With that, I'm going to turn it over to Gabrielle, who's going to start us off with public charge. Thank you again, Gabrielle.
Okay, you should be able to hear me now, correct?
Yeah, we can hear you now, Gabrielle. Thanks.
Okay, great, thank you. So you have probably heard that there are some major changes proposed to the public charge rules. These are based on regulations that were published by the Department of Homeland Security in August. Those were the same regulations that many of us commented on after October of last year. These changes have been put on hold by the federal courts, at least until the litigation involving them is completed. Okay, all right, there we go. Sorry, having a little trouble with the slides. Okay, so public charge is actually a very old part of immigration law. It's been part of the law since the late 1800s. It has to do with who is allowed to come and remain in the United States, and it is not an eligibility factor for enrollment in public health insurance or coverage programs, although we'll be looking at that intersection today. So for many years, immigration law has defined public charge as a person who is primarily dependent on the government for subsistence. And since guidance published in 1999, this has been defined as the use of cash assistance for income maintenance. This is a cash grant that the person is actually intended to live off of, not anything like short-term emergency or special purpose cash, like, for example, a FEMA grant. So it would include things like SSI, temporary assistance to needy families, general assistance or general relief, and it does include cash assistance programs that are from the state or local level government. The other factor that would make a person a public charge is if they were institutionalized for long-term care at government expense. And that would mean that they were in long-term care and it was being paid for by a means-tested program like Medicaid. Medicare actually would not count for this purpose. So the public charge assessment is forward-looking. The immigration agent, and this would be done in the United States by U.S. Citizenship and Immigration Services, they are looking at whether the person is likely to become a public charge at some point in the future. The law requires those officials to look at a number of different factors, which as lawyers we call totality of circumstances. That just means all the facts. And in the law, it requires them to look at the person's age, health, financial resources, dependence, and their skills and work experience. Many people affected by public charge will also have a sponsor who has executed an affidavit of support on their behalf. this is required for family-based immigrants and some others. If they have a sponsor, then the immigration agent will also look at the sufficiency of that affidavit of support. Important to note that people do not need to have received any benefits to be deemed likely to become a public charge. If the person has applied for or received benefits in the past, that can be taken into consideration in looking at their financial status, but under the current guidance, the only benefits that can be considered are those cash or long-term care benefits. So public charge assessments are completed at certain points in a person's immigration journey. So first, when a person is outside the United States seeking permission to come to this country, and that would be conducted at a consular office in that other country. And then when the person is trying to become a lawful permanent resident, which we call an LPR, it's also commonly called getting a green card. Getting LPR status is really important for people because it gives them the ability to settle permanently in the United States, and as Shelby said, remain with their families. It can only be taken away under very limited circumstances. It's primarily when the person decides that they want to renounce their relationship with this country. One situation where people do need to be aware, however, is that when people leave the United States for 180 continuous days, which is 6 months, then that would be considered to be an indication that they had given up their permanent resident status. So they could be assessed to determine whether they were admissible to the United States when they returned, including an assessment of whether they were likely to become a public charge. Once a person has become an LPR, when they apply to become a naturalized citizen, there is no public charge test at that point in time. There's also no public charge test when a person renews their green cards. Permanent resident status is, as it says, permanent, but the card that evidences that status actually expires every 10 years. So people do need to return it, but they will not be assessed for public charge at that point in time. So public charge primarily affects people who are family-based immigrants. To a lesser extent, people who are seeking immigration status based on employment are also assessed for public charge purposes, but they're employed. So they're less likely to be considered likely to become a public charge. Really important to know as you work with consumers that there are many immigrants who have no reason to be concerned about public charge because their status is completely exempt from public charge and admissibility. These are generally people whose status is based on humanitarian reasons and include refugees, people granted asylum, people who are applying for or who have a T visa as a survivor of trafficking, people who are applying for or who have a U visa as a survivor of serious crimes, many survivors of domestic violence, including people who are petitioning for themselves under the Violence Against Women Act, and special immigrant juveniles, which are kids who have been abandoned or abused so badly that they are deemed to have been abandoned. So moving to some examples. So we have our family. Ricky and Ava are married. They have a daughter whose name is Karina. Ricky has been a lawful permanent resident for 6 years. People can be a lawful permanent resident for years and years. There's no requirement that they become a citizen unless they want to. Ava is getting her PhD, and she is on a long-term student visa. And Karina was born here, so she's a U.S. citizen. So which of them is likely to undergo a public charge assessment? Ava is applying through a family-based visa from Ricky to obtain permanent resident status. So she is going to undergo a public charge assessment. She's not a humanitarian immigrant who's exempt. She's a family-based immigrant. Ricky is seeking to become a citizen. So there will be no public charge assessment in the application process for becoming a citizen. However, as a permanent resident, if he leaves the U.S. for more than 6 months, he may go through a public charge assessment when he returns. And then Karina is a citizen, so she will never have to go through a public charge assessment. All right, now we're going to switch gears to how public charge use is factored into public charge assessment. We're going to be talking about the current rules, which are the rules that have been in effect since 1999. And I want to note that even though we're focusing here as assisters on public benefits is just one piece of the picture. And again, as Shelby said, because of the intersection of immigrants' limited eligibility for benefits and the exemptions from public charge, few people who are subject to a public charge determination are going to be eligible for any of the benefits that would be considered in a public charge assessment. So there are actually 3 federal agencies that make public charge assessments. First of all, for immigration decisions within the United States, that's done by the Department of Homeland Security, primarily U.S. Citizenship and Immigration Services. The second is the State Department for immigration-related decisions outside of the United States. And then the third is the Department of Justice for immigration-related appeals and deportation of people who have already become a public charge, which is extremely rare. Just a note about the role of the Department of Justice here, which is that immigration judges are actually, and the immigration courts are actually Department of Justice employees. They are not in the judicial branch, so that's why they are involved in this process. We know that DOJ is working on some new public charge regulations. They have not proposed any policy changes at this point in time, so we are not going to talk about that today. Okay, so the Homeland Security public charge assessments. Again, these are completed for people within the United States, primarily people who are trying to adjust their status to become permanent residents. The immigration officials will try to determine if the person is likely to become a public charge at some point in the future, which under current policy is defined by the use of cash assistance for income maintenance or institutional care, long-term institutional care that's paid for by the government. In making this assessment, they take into account the totality of circumstances test that's set out in the statute, which requires them to look at the person's age, health, financial resources, dependents, and their skills and work experience. The State Department conducts the public charge assessments outside of the United States, and these are done by officials called consular officers. The consular officers also try to determine if the individual is likely to become primarily dependent on the government for subsistence, as defined by the use of cash assistance for income maintenance and long-term care at government expense. Now, in doing that, they take into account that totality of circumstances test, age, health, financial status, skills and experience, etc. However, the guidance that the State Department implemented about public charge assessments in January of 2018 also tells consular officers that in looking at a person's financial status, they can look at whether the person has used any public benefit. So not just the 2 benefits that are the definition of public charge, as well as whether their close family members, dependent child or spouse, have used public benefits. Now, it's unclear that these benefits are actually factored in. We have been trying to find information about denials based on the use of benefits by family members, and we haven't gotten this information. But this is the current test and something to be aware of. So which agency will be processing this person's immigration application, and which agency's public charge policies will apply? So Ava is adjusting to become a lawful permanent resident. She is a family-based immigrant who will do this in the United States, so the Department of Homeland Security policy will apply to her. Ricky is seeking to become a naturalized citizen. There will be no public charge assessment as part of his naturalization application. However, if he leaves the U.S. for more than 6 months, when he returns, the likelihood that he will become a public charge will be assessed by the Department of Homeland Security, in this case, Customs and Border Patrol at the port of entry. He also will periodically have to renew his green card. There will not be a public charge assessment when he does that. And of course, Karina is a citizen, so she will never be subject to a public charge assessment. Now, moving forward in time, Ricky has become a naturalized citizen. And Marta, Ricky's mother, wants to immigrate to the U.S. with him as her sponsor. So which agency will process her immigration activity? She's outside the United States applying to come to the United States, so the agency that will process her application is the State Department. All right, talking a little bit more about how benefits factor into the public charge assessment. And just a reminder, we don't have time to talk about eligibility today, but the last webinar that we did was about benefits eligibility, and there's a recording and slides available on the Beyond the Basics website. Okay, so Ava will be subject to a public charge assessment because she's adjusting to LPR status, but the only benefits that she will be eligible as an applicant for that status is a plan through the marketplace. She's eligible to receive subsidies, but cannot get another program like Medicaid, sorry. Ricky's now back to being a permanent resident. He will not be assessed for public charge unless he leaves the country for more than 6 months, and that's continuously. Depending on the state that he's in, he may be eligible, and his income, he may be eligible for Medicaid or a plan through the marketplace. Under the current policy, neither of those benefits would be factored in the public charge assessment. Karina, again, is not subject to the public charge assessment. She could get Medicaid or CHIP or a marketplace plan depending on the family income, and those benefits will not be considered in the public charge assessment. And then Marta is not yet in the United States, so she doesn't have residency and would not qualify for a marketplace plan or any other program. Okay, so would using benefits negatively impact a public charge assessment under the State Department policy? So Ava is adjusting to become a permanent resident. She could enroll in a plan through the marketplace, but that would not be considered in a public charge assessment. Ricky, again, is a permanent resident, and he may be assessed for public charge if he leaves the country for more than 6 months. Could be eligible for Medicaid or the marketplace, but those benefits would not be factored in the public charge test. Karina, again, a citizen, she could get Medicaid or a marketplace plan, no public charge test. But Mom, Marta, will be trying to obtain permission to come to the United States. She can't be enrolled in a benefit program before she becomes a resident, but she will be assessed by the State Department, and it's possible that enrollment of her sponsor, Ricky, or another close family members could be reviewed as part of her public charge determination. Now, questions that would help consumers think about whether they would be at risk of being considered for a public charge. First of all, are they eligible for help getting health coverage? Are they eligible for any kind of public benefits or only for a marketplace plan? And then, are they a person who is likely to undergo a public charge assessment? Are they not yet a permanent resident or a permanent resident who's planning to take a long trip outside of the country? And are they not in any of the exempt categories? And by the way, people who come in an exempt category like a refugee remain exempt when they become a permanent resident. And then, people need to think about what it would mean for themselves and their families if they were going without sufficient health coverage or other kinds of benefit supports like food and housing for their family health, and their financial status. It would make no sense for a person to avoid using Medicaid because they were worried about becoming a public charge and then becoming financially destitute as a result, which would also be something that would be a negative factor in the public charge assessment. Okay, now we're going to shift gears to the proposed changes in the public charge rule. So the rule that the Department of Homeland Security has published that has been put on hold by the courts would radically change the definition of public charge. It would also add additional benefits to the public charge test, as well as add a number of standards and factors to that totality of circumstances test, such as requiring people to have a certain minimum level of income. So the current rule is that a person is likely to become a public charge if they are likely to become primarily dependent on the government for subsistence. And the benefits that are counted in that determination are just cash assistance for income maintenance received from any level of government. Also, long-term care that is paid for by the government through a means-tested program, not Medicare. The rule that Homeland Security has published that has been put on hold by the courts would consider a person to be a public charge if they received one or more specified public benefits for more than 12 months in the aggregate within any 36-month period. But important to note that they would count the benefits so that receiving 2 benefits in 1 month would count as 2 months. So for example, if a person were receiving both SNAP, formerly called food stamps, and Medicaid for 6 months, they would be considered to have received benefits for 12 months. The benefits that will be considered are cash assistance from any level of government, Medicaid with exceptions, notably exceptions for children and young adults under 21 years of age, pregnant women, including 60 days after the end of the pregnancy, and emergency Medicaid. And then SNAP, again, that's formerly food stamps, sometimes called EBT. And then Section 8, both Section 8 vouchers that a person would take out into the community, and project-based Section 8 assistance, which many nonprofit low-income housing developers use to finance their projects, and public housing. So again, the changes that Department of Homeland Security has proposed to the public charge rule have been put on hold by the courts. Several courts have granted what's called a nationwide preliminary injunction, which means that the public charge rules cannot go into effect anywhere in the United States until all of those court orders are reversed or there is a final determination in the litigation that says that they can go into effect. Now, the State Department has also issued new public charge rules. It issued an interim final rule. What that means is that the State Department decided that it was important to put this rule into effect immediately so that it was not going to have a notice and comment period before the rule went into effect like Department of Homeland Security did. Its rule was supposed to go into effect immediately, but its implementation has been put on hold until it can develop new forms. And there will be a 60-day comment period for the forms. So that's held up for some period of time. And then it would significantly change public charge, but it would change it to conform to the Department of Homeland Security rules. So we have a pretty good idea about what that would look like. So what benefits use would be factored into a public charge assessment under the new rules if they were to go into effect? So again, Ava, adjusting to LPR status, will be subject to a public charge assessment, but she's only eligible for marketplace coverage, which is actually a positive factor in the public charge assessment under the new rules. Ricky, as a permanent resident, can only be assessed for public charge if he leaves the country for more than 180 days. If he's already become a citizen, that goes away. He will not ever be assessed for public charge. And he can be enrolled in Medicaid or the marketplace depending on the state and the income level. His Medicaid use could be considered as a factor under the income element of the totality of circumstances test. Karina could get Medicaid, CHIP, marketplace coverage as a citizen, but would not ever go through a public charge test. And then Marta, when trying to come into the United States, her use of Medicaid could be factored in under the State Department rules. But if she'd never lived in the United States, then she would never have been able to get Medicaid. All right, so at this point, I am going to turn it back over to Shelby to talk about the proclamation.
Thank you so much, Gabrielle. So as I mentioned, there was a new policy change that came via a proclamation that President Trump issued a little while ago. And it is scheduled to be implemented on November 3rd. And what the proclamation would do is that it would be applicable to certain people who are trying to enter the US from abroad. So through consular offices, they're going through that processing. And what it would require of them is to have health insurance or be able to identify that they will be able to get health coverage within 30 days here in the US, or that they can demonstrate that they have the financial means to pay for any reasonably anticipated medical expenses. So that is the new requirement that that immigrants will have based off of what was set forth in the proclamation. We have very little detail about what all of this means, except for what's in the proclamation at this point in time. So primarily, people seeking family-based immigration visas abroad are the folks who would be impacted. There are other groups, including people with coming in with diversity visas or employment-based immigration visas. But in general, when we're thinking about who might be, put through this new requirement, we're talking about people who are coming in based off of some type of family-based immigration pathway to come into the U.S. The type of coverage that would satisfy the mandate include things like having employer-sponsored health plans. So like, let's say somebody is coming in because they are getting married to somebody maybe who's living here in the US, or maybe an adult child or something like that, to somebody who's able to get into somebody's employer-sponsored plan. Maybe the immigrant themselves is coming into an employer-based visa, and that comes with some type of employer-sponsored health plan. Other types of coverage we list here. A couple of things that I want to note for you is that they're very clear in the proclamation that some of these non-ACA plans are, ACA compliant plans are acceptable. So for example, short-term health plans are acceptable under this mandate, which, these plans don't offer full comprehensive coverage. They don't have all the kind of consumer protections under the ACA. And then here we have a list of other plans. Very notable, they are in general not allowing Medicaid to satisfy the requirement, except for children age 18 or younger. And ACA marketplace plans are acceptable, except they're not acceptable to meet the plan if the ACA marketplace plan has financial assistance along with it. So in other words, if somebody's getting premium tax credits and cost sharing reductions, or cost sharing reductions, that would not be acceptable for adults or children under these rules, under this new requirement. However, I really, really want to make a few really important points about this. And I want to start by saying that this assessment will be made for some people entering the US, not for people who are here within the US right now. And quite frankly, by not allowing people to demonstrate they can meet the mandate via subsidized ACA marketplace coverage, it really might make it so that some people feel like they would be better off to just like not get subsidized ACA coverage, and instead they would want to, maybe they think it's a better idea to get a short-term plan. However, that short-term plan could really leave them with some significant financial, exposed to some significant financial risk if they end up needing medical care. And as Gabrielle mentioned earlier, ultimately, people who do end up having to go through a public charge, determination at one point or another, it's important for them to demonstrate that they are financially healthy. There's going to be some other tests beyond just past use of benefits that we've really focused our conversation about today. So that's important to keep in mind. And short-term plans really do leave people exposed. It's that's something that people would have to weigh out. Also, people in the U.S. should really, not change how they would otherwise select to obtain health coverage because of this. Because if somebody, must end up leaving the U.S. to get the new status, which that would be the only time, right? You have to, this is a policy that is only applicable to people who are coming into the U.S. So if I'm already here in the U.S., I should make no changes to how I was planning on getting health insurance, right? If I was going to get employer-sponsored insurance, I should get employer-sponsored insurance. If I was getting marketplace coverage, I should continue getting marketplace coverage, even if it's with a subsidy. If I was eligible for Medicaid, I should continue if that's how I was planning on doing it. We don't see any reason why somebody would change their mind based off of what was in this proclamation. And that's because if, let's say, somebody must leave the U.S. In order to get some type of new status, which, they would know ahead of time that that's going to happen to them. And at that point in time, and quite frankly, if they're going to leave for an extended period of time, they're not going to even be eligible to have any of those kinds of coverage, and maintain them for an extended period of time if, they're leaving for quite a while. And even if they're leaving for a short period of time in order to re-enter and go through processing abroad of their immigration status, they still have time to disenroll if they choose to disenroll, if they, that's what they'd have to do. And then they can make a decision about what kind of coverage can meet this new requirement at the point in time when they're trying to seek re-entry or go through consular processing. So in other words, the big takeaway here is that we don't see any urgency about people changing the way that they plan on getting health insurance based off of what the proclamation has done in the change of policy. I'm going to pause for a second to see if we have any questions.
Yeah, so at this time we do have a couple of questions. Can you just clarify, buying a plan through the marketplace is not factored against an immigrant, is that correct?
Yeah, it's not factored negatively in any of the policies that we've talked about today. So it's not factored negatively as somebody with, going through public charge assessment in any of the existing, policies that go through a public charge assessment, nor is it something that would negatively impact somebody who is going through a public charge assessment based off of the rule changes that the government has been seeking. And in fact, getting health insurance is a positive factor in a public charge assessment in the rules that the government is seeking to do. When we think about the proclamation, which is a policy, again, that we have very little detail on right now, other than what was in the proclamation. But in the proclamation, a person newly entering the US would have to show that they have health insurance. What the proclamation is saying is that that person newly entering the US, trying to get that immigration status, they won't be able to satisfy the mandate for having health insurance by having a marketplace plan that is subsidized with premium tax credits and cost sharing reductions. They would have to do something different to be able to cross that barrier. But for somebody who's in the US, there's no reason to change, how their preference, would have been otherwise in terms of enrolling in a marketplace plan with premium tax credits and cost sharing reductions. Because if they were to have to leave, they could change, they could change their mind about how they're getting health insurance before that, all of that would happen. Okay, we're going to go ahead and go on to the last section of our presentation, where we're going to go through some rules, related to the application process itself when people go through the application. And the reason why we're going to kind of talk about, privacy is that, a lot of immigrants, given this climate of fear, they get worried about providing their information, disclosing information on applications, with sharing information with anybody, quite frankly, but certainly on, government websites. So what's important to know is that there are very strong privacy rules in Medicaid and Marketplace and CHIP applications, including, protecting the information, any information that's disclosed about family members who have different immigration statuses, even if they're what we call non-applicants in the application. Their information that's provided in the application for other members of the family is still protected. And in general, the use of the information that's provided in applications is limited to be used for the purpose that it's being provided. In other words, for eligibility and enrollment purposes. So there are some strong privacy protection rules in place. So when people are applying for health coverage programs, the households can include both applicants and non-applicants. So applicants are people who they themselves are trying to get some type of health coverage, and non-applicants are people who are in their households, with applicants, but they themselves are not trying to get any kind of coverage for health coverage for themselves. And non-applicants, when we think about Medicaid, CHIP, and Marketplace applications, they do not have to share information about their citizenship or immigration status. But they might have to provide other information that's really important in making the eligibility determination, such as income. That information they could be asking. And we have some examples of screenshots that show how you identify people, who are applying or not applying in healthcare.gov. The applications for Medicaid, CHIP, and Marketplace, they all have different ways of asking about SSNs. SSNs are generally required of Medicaid applicants, but coverage can't be denied or delayed pending issuance or verification of a Social Security number for somebody who they themselves is applying for Medicaid. And Medicaid agencies must even, they must offer help when somebody needs help, says, I need help getting an SSN. Some applicants do not have to provide Social Security numbers, and this includes people like newborns and when they're in the process of obtaining SSNs, people who have a religious objection. Certain immigrants also don't have to provide an SSN if they're not eligible to have one, or can only get an SSN for non-work purposes. So there are certain people, and remembering that there are certain people who are eligible, like, for Medicaid, but yet are not eligible for an SSN. So that is important to remember. So we can't like force people. And then in the marketplace, only applicants who have an SSN are required to provide one. So, and now we're thinking about people who on the application who are not applying for benefits for themselves, so non-applicants. In Medicaid and CHIP, the rule is pretty clear. Non-applicant household members do not have to provide an SSN when somebody in their household, when the reason why they're showing up on an application is only because there's some in somebody's household that is applying for benefits, even though they themselves are not. So non-applicants don't have to provide SSN. In the marketplace, non-applicant household members should not be required to provide SSNs unless all of the following are true. The non-applicant is a tax filer. The SSN is not required for non-applicant tax dependents. The non-applicant has an SSN. The non-applicant filed a federal tax return in the last year. So only in the case that all of those are true would somebody be required to provide an SSN in the application. So that's just important to note that, again, non-applicants should not be required to provide an SSN if they don't have one. We also wanted to add some tips about talking about immigration status with families. We should never want non-applicants to, we should never ask somebody who is not applying for benefits for themselves what their citizenship or immigration status is, okay? Also, using broad questions is preferable. When we're asking people information about immigrant eligibility, when we're trying to think about who is and is not applying in a household, and try to be as welcoming as possible, and really avoid trying to use words like, is somebody undocumented or not legally in the US? Instead, we really lean on utilizing words like the words that are used in the applications themselves, like, does this person have a satisfactory immigration status, or an eligible immigration status, or statuses considered eligible for marketplace coverage, and then providing people a list. These are the statuses we're talking about. Like, that is a preferable way of walking somebody through if and when they're not sure if they want to be an applicant or a non-applicant, as opposed to saying, is this person undocumented, or is this person legal or not legal, or does this person have DACA? Those things are asking for too much specificity and could make people uncomfortable. With that, I am going to just share that there is an abundance of great resources on the National Immigration Law Center website, also in the Protecting Immigrant Families websites, where there's a lot of good information. Kaiser Family Foundation has some good resources, especially around that proclamation that I talked a little bit about. We have a webinar coming up, and Ina is going to tell us a little bit about that before I close this off.